Tell your executor you want to be cremated and tell them where you want the ashes spread, but I will not put it into a legal document. I'm Jeff Mersace. I am known as the Plain English Attorney, and the reason I'm known as the Plain English Attorney, that's my big strength, is being able to explain some complex things in everyday language. And I think I really kind of honed this skill by avoiding talking to other attorneys as much as possible. When attorneys get together, they start what I call code talking. Well, according to regulation 3625-3, this is what it means. Oh, but the person case ends up throwing all that out. Do you talk to your clients like that? It's kind of like saying, do you kiss your mother with that mouth? No, don't talk like that. Explain things in a way that's going to help people understand. So that's what I do. So I've done that for many years. I've got a YouTube channel that's got to be coming up on periodically 8 or 9 years. I've got several books. That was kind of my whole rule, is if I had to explain the same thing more than 3 times in a week, and it took more than 20 minutes to explain it, okay, time to write a book on it. So I have several books out there. We've got some resources and websites there. I've got a lot of free stuff online that talks about estate planning. Yes?
Where do pets fit in?
Where do pets fit in? I'm sorry, your pets may be one of your most trusted loved ones, but they are not allowed to be trustees under North Carolina law. Pets are kind of considered property. So you can put in the trust where they go. But most of the time, my clients are okay with whoever they've got listed as their trustee just taking charge and finding a home. So it's a very common thing. If it's specifically we want to talk about pets, we will grant whomever the trustee is, quote, a power of appointment over any pets and give them the full authority to find a home with it. Sometimes we pair that up with dollar amounts to help with taking care of the pets, but usually we do it as a set dollar sum per dog or set dollar sum per cat, so that you don't need to redo your estate plan if you're, like I've been in the past, oh, there's a stray cat, we're never going to take them in, and then a month or 2 later my wife has convinced me, yeah, we're keeping this cat. It's already built in. So that's kind of how we handle pets most of the time. We haven't come across anybody that does the whole Leona Helmsley thing of leaving the estate to their pet. Closest I had was a client out in Asheville. She wanted to leave her house to a local animal shelter. But part of the deal was any cats that she has that are still alive when she dies must be allowed to live in the house. The shelter will provide care and food, come in at least twice a day to play with them, and then when the last cat dies of natural causes, they can do what they want with the house. We were able to draft that, but that's not usually how most people want to handle things. All right. Any other questions?
Anything you draft also has to be legal, right? Like you couldn't create a situation where somebody's got pets in the walls or, doing something.
I
that's
hereby donate my cocaine farm
Right.
to.
Right.
No.
Those sorts of things are just completely off.
Yeah, now, okay, you open the door for this one. I sometimes have clients, well, I want you to put into the will or the trust or wherever that I want my body cremated and my ashes spread. Nope, hold on.
Right.
About 75% of the time when people say where they want their ashes spread and you look it up, it's illegal to do so.
Yeah.
Tell your executor you want to be cremated and tell them where you want the ashes spread, but I will not put it into a legal document. So that's how that's usually handled. It's extremely easy If you're leaving something in your estate, well, it's not part of your estate tax. If it's a 501c3 charity, whatever you're leaving in a will or a trust to a charity, it's not considered part of being estate taxable. Okay, that's the easy one. But what kind of tax breaks can you get? Here's an easy one. Let's just say that you are in the habit of annually giving, say, $10,000 to your church's foundation. But you do it after you take your annual distribution out of your required distributions. Well, wait a minute. The far better way to do that, and this is all mechanical, but it has a big impact. You can direct the money from your IRA directly to the charity. Well, why would you do it that way? When you pull money out of your IRA or 401k, it's income taxable, so it goes on your taxes as being pulled out, it's income. Oh, well, I'm just deducting it after. Yeah, you're deducting that. But the number that you come up with after that first part in your taxes, that applies towards how much tax you have to pay on your Social Security. And I'm not fully up on this, so I'm just telling you what someone else told me. Don't hold me to it. It actually can affect how much you have to pay towards Medicare. So whatever Medicare plan you're on if you're over 65. If it goes directly from the IRA, it doesn't show up in that Part 1 at all. So that's just an easier way that can save you some money on your own taxes.
If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel.
Another one, and this is a little more of a, I don't want to say a specialty area. It isn't really, it's just not that common. I had a client, he was a dentist, so he had his dental practice, but he also owned the building he was in. And he had some good accountants, so he depreciated that building down to almost nothing. And meanwhile, the value of that tripled. And so he was going to basically pay the full amount as taxable, I think it was taxable income as, quote, capital gains recapture. So it went from like a $300,000 unit to over $1 million. All of that was going to be taxable. What he did instead, we set up a charitable remainder trust. So technically, he put the office building as a, quote, donation into the charitable remainder trust. The charity sold the property. It was everybody was already on board. We already had the buyer. But because the charity sold the building, there were no income or capital gains taxes on it. In exchange, he gets a stream of income over, I think we set it 15 years, it could be as much as 20 years. Some of it's taxable as income, some of it is taxable gains, but some of it was return of principal. It's got spread out over that time period, and the taxes were a lot less. He got big deductions for the first 5 years on his income taxes for the, quote, donation. And at the end of the day, the charity got a bunch of money too. So I really don't mind if the only loser in this transaction is Uncle Sam. That's perfectly fine by me. So that's a charitable remainder trust. Now, there is one more that I'm going to talk about that isn't really out there in the mainstream just yet, but it does work and it does make a lot of sense. I was just talking with Jim about it earlier. I end up with some clients that have done really well in their IRAs, 401ks, and retirement accounts, and then they reach that point where they're like, I'm going to have to start taking required distributions, and it's a lot of money. Let's say you've got 2 kids, you want them to inherit your retirement accounts, and there's $2 million in there. That's $1 million per kid. It's all income taxable. They only have 10 years to pull that money out. So assuming no growth or anything, it just stays exactly the same. They're going to be putting an extra $100,000 on their 1040 is taxable income for each of the next 10 years. That's gonna it's like a tax bomb. And that's if they actually spread it out evenly. I've had and heard of clients where their kids, I don't want to take money out this year, I've made too much money. And the next year, I've made too much money, and I made too much money. Imagine if they take all of it out in the last 2 years, they're going to get absolutely slaughtered with taxes. If instead, it's the same kind of theory as a charitable remainder trust, but it's a testamentary charitable remainder trust. In other words, you set up this charitable remainder trust now, but you're listing it as the pay on death beneficiary for that retirement account. And now, again, just like with the charitable remainder trust, the contract says these beneficiaries get this stream of income over whatever period of time it is. So now it can actually extend way beyond 10 years for that beneficiary. And an extremely common thing to do, but way more complex than I'm going to get into, which is why you absolutely need an accountant who knows what they're doing if we're going to do this. They calculate the numbers and they come up with, okay, we're just going to put this into, quote, an immediate annuity, so you're just going to get this income stream for the rest of your life beneficiary, which could be 20 years, it could be 60 years. They're still going to get that payment, and it's still going to have the same percentage and proportion of taxes. But they're not having to add all of that money onto their income taxes over a 10-year period at best. So, and same thing as with the charitable remainder trust, there's a sum of money that's going to the charity. And the only loser in that is Uncle Sam. That's not going to get your kids to have to put an extra $100,000 on their income taxes each year. So that's something that I can go into more detail, and I probably will. I think I have one video up on the channel at this point that talks a little bit about that. But I know I'm going to be doing more of that in the future.
Yeah.
Yeah.
Sorry. That's called what? That is good information, because here's my concern, one of my concerns. So I'm an only child of essentially 4 parents. My parents separated and remarried. So, and they're all in the same age bracket. So I'm not saying they're all gonna die at the same time, but it's likely. So like, it could be a 4-year period where all of a sudden I have all this stuff funneling in. This is the tool I would use to kind of deal with that.
They would.
Or they would.
They
use.
would, yeah.
They would use.
They should be here.
Well, that's why I'm here, because I'm giving
Yeah.
all this information back to them.
Yeah.
And say, do this.
Yeah.
Okay.
All right.
So, just back to the more mundane example. For the last couple of years, we've started giving our annual giving to UFR through a direct. All of our money's in TIACREF. We send one form to TIACREF once a year, and we say, send our annual pledge amount to UFR. And as Jeff said, that removes it from our tax form. Well, the reason we do it is because we don't have, our standard deduction for a couple is over $25,000 now. We don't have $25,000 worth of deductions. So if we pay it to the church and try to write and itemize, we're going to lose.
Yeah.
We're not going to get up to 25, and actually I think it's more like 28 maybe. So we've started doing that, and it also, this was the first year that Hetty has required minimum distribution. That addresses that issue. We get to subtract that from her required minimum distribution.
Yeah.
Do you have accountants that you recommend? I mean, it sounds like it really has to be sort of a both and, right? I mean,
Yeah, unfortunately, the accountant we were referring people to was fantastic and just got so busy that she just couldn't take anybody new. Now, I do have somebody, a a financial advisor that I work with out in Asheville, and he's got a whole kind of tax practice that goes along with it. They're good at what they do. They have one or two people that can specifically look into some of these more complex things and handle things. It's just you got to be okay dealing with somebody from Asheville. The other thing is I do have somebody that I'm kind of working on right now, but her entire business is remote, and I think it's Illinois or Indiana. And if you're okay with scanning and emailing stuff and getting scanned and emailed stuff back and working and communicating that way, it looks very promising so far. So, but this is not the time of the year where I'm gonna be able to get them on the phone too often. Yeah. Yes.
Can you redo or do another revocable trust that takes precedence over the prior one?
We do that. In fact, this also how I end up doing quote trust amendments. We've had clients come in and I looked at their trusts and I'm like, okay, you know it does this. Oh, I don't know if I really like that. Well, it does this, and here's a lot of provisions that are missing. They've already put their assets into their trust. So we do, quote, an amendment and restatement. So we keep the name of the trust. The assets are still part of the trust, but we've changed all the terms to the documents that we use that really comprise the biggest document in here that cover a whole lot of circumstances. So it's just replacing the language, but they don't have to refund their revocable trust. The other thing is when we have our own clients that are, we need to do an amendment, we need to change. We're cutting one of the kids out. We want to have it instead go here, and here's how this works. All right, that's just the trust. We don't have to change any of the trustees or the power of attorney. Okay, but it's just the trust. I'm gonna make the changes, call that an amendment and restatement, and print out the whole document again and sign it. Well, why do it that way? Can't you just do a couple of page amendment? Going back to one of the Asheville cases about 8 years ago, a gentleman came in and said, look, can you help settle my father's trust? Here's the trust, and it was a decent sized trust. Here's the first amendment to the trust. It was like 3 pages. Here's the third amendment to the trust. It was 2 pages. I said, well, where's the second amendment to the trust? I don't know. I couldn't find it. Okay. I said, I don't really know what we can do until we find that. Can you contact the attorney? Well, he really, really dug into his father's office. He found it. 2 pages. Apparently, Dad had put one of those oversized coffee mugs on it. The coffee spilled over and got sticky. It stuck to the bottom of a stock prospectus in the bottom drawer. He found it. Okay. I had to go through, all right, here's the trust, here's the first amendment, here's the second amendment, here's the third amendment. Okay, read the trust. All right, let me read through this. Okay, that changed this. I had to go back there. Okay, that's what this means. Go to the second amendment. All right, did that change that same thing? It took like really almost an extra 3 or 4 hours to understand what the whole thing meant in total with all of the changes that were made through these amendments. If you just print out, quote, an amendment and restatement, the last document is everything, and that's not going to get stuck to the bottom of the stock prospectus. It's just way too thick. So that's how we end up doing the amendments and restatements rather than the small amendments, at least most of the time. If you're doing it yourself, you're doing it yourself. Okay. If someone's coming in and says, yeah, we've got all of these changes, here's a Virginia document or a Wyoming document or whatever, and look, here's how I review trusts, and I look through them and I can tell you what the stats are. 80% of the trusts that I read are just these little thin things. They don't cover nearly as much as my clients want them to. All right, we really should put you into something better. About 15%, yeah, these are darn good. And maybe if there is a change, I can do it with an amendment. We don't need to redo everything. There's only about 5% where I go, yeah, okay, that's pretty good. here's where the deficiencies are. I don't know if it's enough to do the whole thing. It's really a flip of a coin. So really, only 5% of the trusts that I review end up kind of just being pretty good. They're either the 15% that are really good, or yeah, we need to do something big here.
So you don't think state laws are different enough, let's say, just on average, right? I'm not gonna.
I have to, well, that's kind of the same stats. I have to read it and go through it and see. Like I just, in fact, just today, I read a trust that somebody said, here, can you please review this? I want to make sure everything's good. And I found some pretty big things that shouldn't be the way it was. It might actually affect the property. And then I looked closer. I was like, he drafted his own trust and gave it to me, and he didn't handle a couple of things the right way. So I'll bring that to his attention and see what he wants to do. But that's just reviewing the trusts. Yeah.
Advice for handling situations with kids who have mental health or substance issues, you know, how do you deal with succession under those circumstances?
Well, we can talk about specifically what the issues are and how long of a thing is this going on, because what we can do, and we have done it, we just kind of lock up that inheritance. So it's always in the discretion of a trustee. So they can give them money over time. If they see a problem, they can stop. It's never going outright to them unless the trustee says, yes, everything has been fine for a significant period of time. So yeah, it means they're never going to get it, quote, outright, but that's what the trustee is there for. The other thing we have to think about in those circumstances is if they're younger and healthier, but they've just got these huge issues, we're probably going to put a trust company in after those people you trust, just to make sure there's some kind of longevity in case something happens to all three of those trustees.
Trust company?
Yeah. They're a professional trustee. They do that as a
I was about to
job.
ask you that.
Under the law, which really means, okay, what if you don't have any plan at all? And it's the, quote, the government plan. Are they considered a child of yours? They have to actually be legally born to you or legally adopted. And for men, if you've, quote, legally acknowledged, it's not like, oh yeah, I went to a party and said, yeah, this is my son. It's, no, there's an actual form. Yes, I am legally acknowledging that I am the parent of this child. If it's not one of those three, they don't count. With that said, the presumption that we put into the documents, and it's the definition in the trust that really matters, because that's what's distributing everything. It's born to or adopted or acknowledged, and then you can decide if you want to include somebody or exclude somebody. And we put in pretty specific language. Look, if we haven't included them here, they are not to be considered a child, and that just kind of cuts the dispute off there. I want to make sure that I'm covering with the handouts. We've got some really good free resources. The big one, freetrustcourse.com. That's a course that I put together. Again, as the name implies, it's free. It's got a copy of my book, Estate Planning Basics, in a PDF format, in an audio format, and I went and did a kind of read-along audio. So I took screenshots of the book, and it just kind of syncs up with the audio. So 3 versions of that's on there. It also includes the pre-appointment questionnaire that we generally ask our clients to fill out. So whether you're going to work with us or not, that's a good tool to help gather the information that most estate planning attorneys are going to want anyway. Of course, they may have their own forms. And I do have something specifically on the big 4 questions and go into that. We keep adding resources every now and then. The other thing is I do have a YouTube channel. We are really creeping up on 5,000 subscribers. At this point, it would have been 2 million if what I did was cat videos, but I don't. So I know there's an like plain English attorney or whatever, but you go to youtube.com/NC Lawyer, that's going to get you to my YouTube channel. We get a new video every week. Plus, we get about 3 or 4 shorts out of that, posts and polls and other things like that. And specifically regarding charities, I did a video, Charities in Estate Planning, it's up as a webinar, and it's at charitiesinestateplanning.com. So it talks about some of those charitable techniques that I mentioned and a few more. So it goes into some of the ins and outs of that.
So,
Yeah.
can you talk about your fees at all?
No. I specifically don't talk about fees other than, look, we're going to do a flat rate fee for almost everything that we do. But I get the question all the time, well, how much do you charge for a will package? How much do you charge for a trust package? I've got this advanced thing, and if we go, well, we charge this for this and this for this and this for this. I actually counted the numbers. 50% of the time, people wanted either the usual trust plan or something more advanced, and the only number they remembered was the one for the simple will package. And so I don't give those actual numbers. The process, though, we're typically doing a free 30-minute phone call, just making sure we understand the basics of the issues so that if you need something in addition to freetrustcourse.com, I've got some other special materials on, oh, I've got a child with special needs, or we need to talk about Medicaid planning because really this is more for my parents than me. Okay, we've got other resources. And then we have a sit down, we call it a strategy session. So that's an hour and a half. It's free. If you read the book and you fill out the questionnaire and get it to us. If you do that, okay, then we can go through and come up with the general plan. Here's what, the people that you want. We really do put a lot of names in there and get the plan almost sketched out. And at that point, I could tell you, yeah, this is exactly what it's going to cost, and here's the process that we go through. And I do it like that because when we used to charge by the hour, I could give my clients the best plan in the world, but they avoided asking questions because they didn't want to add to the bill, and they still ended up upset. When we do it as a flat rate, yeah, this is all it's going to cost. Ask the questions. I want you to understand it. And in particular, I want you to understand it and the funding process, that it's an ongoing thing. So that's how we really work with fees. Let me talk a little bit about the process in the office. When we get to the point where we're signing the documents, we're signing at least 2 sets of originals. So that big blue binder goes home with you. We keep the second set. We scan that second set into signed PDFs, and we make that available to our clients. And then part of what we do is the final meeting in that initial process. We call it a family review meeting. We encourage our clients, bring in, it can be family members, but usually, whether it's family members or not, it's at least the first and second trustee. They're the ones who have to grab the binder in an accident and get things going. So this way they have our information. Part of that meeting is where do you keep this binder? Okay, and so that they know where it is. And they have our information if they can't find the binder, which has happened, and that's where we've got that second set of originals and we can get going at that point. So yeah, if you're in an accident, somebody has to call us to do something, but usually it's pretty much set up. The people know what their roles are going to be, and they know where to get the information. We talk about this in the funding meeting. If you have a safe deposit box, go down to the bank, retitle it in the name of the trust, so the trust is the owner, and then I tell them, okay, this is being recorded. I tell them to put all of the trustees on as active trustees, whether they're active or not. This way, no matter what happens, any one of your trustees can get into that lockbox. Now, what do most people usually keep in the lockboxes? It should just be like very valuable collectibles, jewelry that they may not use all the time, stuff that just, it needs to be secure. Don't put all of your important papers in the lockbox. What happens if you get into a car accident at 6 o'clock on a Friday and no one can get your healthcare power of attorney documents until Monday at 9?
Oh, dear.
That's not what you want. I've had to go through that process with probate and open the lock boxes, and it's always a big disappointment. Here are 2 car deeds for cars they sold more than 5 years ago. But you had to go through the formal process, you had to have the witnesses, you had to have someone at the bank do the inventory and all this other stuff. It's like, okay. If it's in the trust, you don't have to worry about it. Just make sure all the trustees have access to it in your list.
Legally, like from a legal perspective, does it matter if, do you need both a paper and a digital, or if everything's digital, is there an issue with digital because now everything that's digital can be changed and manipulated? I mean,
I can't see this happening in my lifetime being any different. It's ink on paper and originals are needed.
okay.
Oh, well, wait, I redid my mortgage or what, okay. That's fine if you did that digitally. You're paying your mortgage every month and the bank is accepting your payment. It's reinforcement that this is what happens. You go 20 years without changing your trust and it's just a digital copy, someone's going to question it. It's going to become more of a big deal than it needs to be. And every time we think we've gotten to the point where it's, okay, this is, quote, unbreakable digital protection, somebody finds a way to break it. So yeah, we'll have those digital copies so people know, but we're going to keep that extra copy at our office and you're going to have your big blue binder with your own documents in it. All right. Any other questions?
So what happens when you're out of business?
Oh, somebody is going to buy my practice for an insane amount of money and they'll be there. I'll be sitting on a beach somewhere.
They'll know to the heirs. You just have to make sure somebody knows.
Yeah,
Find your document.
this may be a little more technical and inside, but I can't sell my practice to a non-attorney. The state bar keeps track of these things. So even if I get hit by a bus, whoever is buying my practice, and then it's my wife who's sitting on the beach sipping Mai Tais, all right, they'll know who took over that particular practice. And the other thing is if there's a buyout or attorneys change, one of the routine things they do is they just send out letters or emails to everybody. Hey, we've taken over. If you want to come in and review, so you get that updated information.